Well, thank you very much, and it's a pleasure to be here with Jim. And I'd like to just remind everyone that the lawyer's job is to take those stories and anchor them in the fundamental principles of law that will actually change the social fabric and rules that we live by. So we have to shoehorn that into the principles that we all abide. And in this case, I think it's good to step back and not just start at the Supreme Court, because no case starts at the Supreme Court. And when you step back, one thing I'd like you all to know is that another version of this explanation of the development of marriage equality has been made into a documentary by Netflix. And the documentary is called Amend, and it's about the 14th Amendment, which is, as we call it, it's our second founding. Our nation had some great principles when it was first founded, but we also had slavery. So we were living in tandem with contradictions. And those contradictions erupted into a civil war, and we ended up with an amendment, the 14th Amendment, which established very clearly in our founding constitutional document the principles of due process and equal protection. And all of that is explained in this Netflix documentary, including episode 5, which is hosted by Will Smith, the actor, and Jim and I both explain the story that we're telling you here this morning. So if you want to see a jazzier version of all this, watch Netflix and you will see. Am I allowed to screen share here?
Yes.
All right, do you see?
Yes, yeah, we can see it.
All right, do you have marriage equality on your screen?
We have, yes.
Okay, thank you. So I need to start where I was at before I met Jim. And that is, I have been a civil rights lawyer for over 40 years. I was working on notions that people should just be treated equally in the economic environment. So I was not focused on marriage equality. For example, one of my early gay rights cases was against the Cleveland Archdiocese. The Catholic Church had fired my brother's partner because my brother and Mr. Navis were living together. And I thought I could go to canon law and I could explain using church law how they should not be treated so unfairly. And I lost that case. And I will tell you, for many years, I lost cases on behalf of gay people because I was arguing that their economic rights should be equal to all others. And we got to a point where it was so clear that we had no good arguments for gay people that we passed a local human rights ordinance that said you can't discriminate based on sexual orientation or gender identity. And then the city of Cincinnati, which was a very conservative place at the time, passed this anti-gay charter amendment. And our charter is like a little constitution. So this charter amendment said the city will not respect any laws that protect gay people from discrimination. And you're not even allowed to advocate for laws that protect people from discrimination. So I sued to strike that law down, and I won at the district court level. I lost in the Sixth Circuit, and I ultimately lost that case. And for many years, Cincinnati was an island of hatred and intolerance against gay people. So my track record was not going very well in the early years. And then one of the lawyers I worked with, Scott Greenwood, on that case was fired by his law firm for being gay. They outed him and then fired him. So I sued on his behalf and lost that case. So here we are fighting to secure the rights of gay people and losing case after case. And then this man who was out of Harvard Law School wrote a document, a thought piece, saying we should be fighting for the freedom to marry. And I'm out there just fighting for basic jobs. And I thought Evan Wolfson was crazy. I thought that he must be totally nuts. I can't even get a person a job. And here he is trying to get him to be married. So we were on very different wavelengths. And he was right. And I ultimately was wrong and came across and came to adopt his viewpoint. But I bring this up and I start at this place so that you can see that sometimes you have to explore different avenues and pursue different ideas in order to finally come to the right place. And no one person has all the wisdom in the world. I did have an opportunity using our Equal Protection Clause to represent Felicia Barnes in the early years. And she was a transgender African-American sergeant who had experienced discrimination in Cincinnati. And she was demoted, and I sued on her behalf, and we went to a jury trial. And even in this very conservative community, she won before the jury. And it gave me hope that the people of Cincinnati, when they heard the story directly, as Jim was emphasizing, will do the right thing. And so that gave me some hope that there still was a thirst for justice, even in Cincinnati. And then, as Jim mentioned, along came the case of Edie Windsor. Now, generally, one state will just recognize the marriages of another state. And the federal government always recognized the marriages from every state. And what Edie Windsor established was that this business of starting to reject the marriage of Edie by saying that it wasn't going to be recognized was contrary to the whole history of the federal government's treatment of married people. And so the US Supreme Court in that case said, you can't change the rules, federal government, just because the marriage you're looking at is a marriage among same-sex couples. And that's what really got me thinking, and that's what made me realize that Ohio could be viewed as being in the same position as the federal government in the Windsor case. The federal government wasn't allowed to pick and choose which marriages to recognize, and I didn't think Ohio should do that either. So as I thought about people like Jim and John, I compared them to, for example, first cousins. First cousins cannot marry in Ohio. But if a first cousin gets married in Massachusetts where it's legal, and then that couple comes to Cincinnati or to Ohio, their marriage is recognized. Or underage kids. If you're under 16 and you don't have your parents' permission, you cannot marry in Ohio. But in Georgia, you can marry under age 16 without your parents' permission. So if that couple, a young bride and her husband, get married in Georgia and then come to Ohio, Ohio automatically recognizes that marriage. So the argument was, under the notion of equal protection, we should be recognizing marriages among same-sex couples the same way we do with respect to first cousins and underage girls. And so we started to put that argument together along with our notion of due process. As a very conservative state, we didn't immediately sue for the right to marry, because we thought if we could just work on recognizing marriage, we would build that right, we would build toward that right. And we also combined Jim and John's case with cases involving people who were seeking to adopt, same-sex couples seeking to adopt, and expanded the notion. And of course, this is the marriage of Jim and John in the airplane on the tarmac and in Maryland, and that's Aunt Pauline that Jim was just telling you about, and that's one of the most beautiful little videos and events that you could ever witness. So that was totally inspiring to me as I thought about how to put this case together. And of course, you could say, well, what was it that, this man, John, was dying? How could I really be helpful to him? But I have done in the nature, in all the civil rights cases I do a fair number of death cases. And that's why this death certificate was in my mind. And I guess that's warped to think like that, but that's what I do. And I did tell Jim and John that the line on this death certificate for surviving spouse would be blank, and Jim's name should be there. The marital status line for John would be single, and that should be married. And that is the last record of what a person has on earth as far as an official document. And it should be right, and the government shouldn't do it wrong. And we carried that argument into court, as Jim mentioned. Now, one of the interesting things here is combining this with the story notion is that we had to sue the local government, Cincinnati, at the same time we were suing the state for having this unconstitutional law that was blocking marriage recognition. Cincinnati had to be sued because they actually issued death certificates as part of the system for vital records. And when Cincinnati studied all this, and having been through our battle over the Charter Amendment, having been through the struggles we had regarding gay rights in our town, which, by the way, triggered a huge boycott. When we had our battles, I say I lost those cases as if they were worthless. They were not worthless. They did raise recognition. They did raise consciousness. And they did cost the city a ton of money. There were conventions canceled when we had that anti-gay charter amendment. There was a huge public discourse about how unfair it was to be a city that banned recognition and respect and dignity for gays. So by the time we got to this case, and Cincinnati is standing up in court next to us, the lawyer for Cincinnati said, we side with the plaintiffs. We agree that marriage equality should exist, that Ohio should recognize this same-sex marriage, and therefore we are not going to join the state in defending this law. So that was powerful to have part of the government already retreating from this harsh, intolerant attitude that the state had. And of course, along the line of stories, we added additional plaintiffs like the York-Smith family, who are a same-sex couple married in another state who had children, and they wanted their marriage recognized just as much as Jim and John did. We went, as Jim mentioned, to the district court first and won. And then we went to the Sixth Circuit. And Jim is absolutely correct. In the Sixth Circuit, what prevailed was the notion that this is a political matter, and therefore we should just let the political process play out, and we should let the majority decide. And the majority had voted back in 2004 to add to the Ohio Constitution this ban on same-sex marriage. And since the people had voted, the Sixth Circuit was deferential and wanted to say, let's just let the people's voice stand. Now, our argument against that runs from a very central notion in the Federalist Papers, which were the documents written by some of our founders in the early days of the debate about adopting our Constitution. And the Federalist Papers include education for our country about the notion that there are certain fundamental rights, and the whole reason we have courts is that they will protect those fundamental rights that are often held by minorities and people at the margins of power against the tyranny, as they put it, of the majority. So it's central to all civil rights in our country that there be a place, a court that you can go to and defend these very basic civil rights. So we did get to the US Supreme Court, and the background, and by then I was a true believer. I totally agreed with Wolfson that we should be pressing for marriage equality, and we didn't need to use the precedents that were so negative about from economic justice cases. And we did have a very favorable judge in Justice Kennedy. He's someone who had come around on gay rights issues over the years. When I first lost the case involving the Charter Amendment, I was working against a precedent called Bowers versus Hardwick. In Bowers, the Supreme Court had ruled that states are permitted to pass criminal laws that make it a crime for same-sex partners to be intimate. And that was a very difficult case to get around, because if you can't even be in intimate partnership, physical intimacy with the people you love, it's a tall stretch to get to anything like marriage equality. And so Justice Kennedy, having lived with this decision for a couple of decades, reversed with the majority of the Supreme Court the Bowers case in 2004 in a case called Lawrence versus Texas. And in that case, the Supreme Court said, we were wrong in Bowers. As we study the notions, the fundamental notions of privacy, the fundamental notions of due process, we believe now that it's most important that we respect that autonomy of the individual and an individual's opportunity to make their own choices about who they love and how they express that love. So with the Lawrence case, in the language from the Lawrence case, we had a really good opportunity to think that we may be successful. And don't think that courts can act totally independent of social movements. When I started Jim's case, there were about 9 states out of 50 in the United States that recognized same-sex marriages. So, and they were based on different theories. Some had their own state Supreme Courts rule that way, others had voted for it. It was a very small group of states. By the time we got to the Supreme Court, 21 states had decided that they would recognize same-sex marriage from other states. And many of those states had also adopted the fundamental principle that they would permit same-sex couples to marry in their states. So that was a really important movement that was already underway, supported by political advocacy, supported by a large awareness campaign within the media and television shows and movies and other ways in which stories are portrayed that normalize same-sex couples, permitting more and more people to come out, permitting more and more families to meet the full person who's in their midst. And that was very, very important, this whole groundswell, the social media, the public recognition, the growing public recognition of marriage equality. The Supreme Court argument was in April. Their decision came out in June when Jim and I were there. And the decision was really very profound because it started with a long history of the significance of marriage. And that our due process clause gives us a place to look at the impact of history on these fundamental institutions. And one of the things that was so powerful to the court was that we were not changing marriage with our argument. We were simply making marriage more open to people who had been left aside. And the Supreme Court had done this before, most famously in our history, in the Loving case. In 1967, the Supreme Court struck down laws that banned white people from marrying Black people. And that type of law was struck down because marriage is fundamental, and it shouldn't depend on the color of the skin of the people getting married. So there, the Supreme Court had said marriage is a fundamental institution that should be open to all, regardless of the color of their skin. Similarly, later on, Wisconsin had passed a law that said, if you owe child support, you can't get remarried to another woman until you pay your child support. And in Zablocki, the Supreme Court struck that down as well, because the Supreme Court said, well, marriage is a bigger deal than child support. And while the state can enforce child support laws, they can't condition marriage on child support obligations, because marriage is bigger, marriage is more significant. And that was an important precedent for us. And then a case that was very important to me, because I had litigated this type of case before, was Turner. In Turner, the Supreme Court said prisoners have a fundamental right to get married. Again, just opening the door wider, not changing marriage, but opening it wider, because it's such an influential and fundamental right in the history of our society. And then the court further traced the history of women in marriage. Originally, when people would get married, it was almost like the woman became a slave to the husband. And there was a law of coverture, which basically controlled the economic rights of women. That was struck down by the courts years and years ago. And the equal rights came about as a result of litigation and divorce proceedings. So this whole history that the court traced in our decision helped us realize that marriage is fundamental, but marriage has also been changing and evolving as our notions of fairness and due process changed and evolved. And the court also accepted the argument based on equal protection under the law, meaning that same-sex couples should have the same rights as opposite-sex couples. And then above all else, I think in terms of the stories that really influenced the court, and particularly Justice Kennedy, was the notion that children deserve family homes. There was a lot, both in the Windsor case and in our case, about how many children are being raised by same-sex couples, and how important it is that the government provide for those children stable, secure, loving homes that are not attacked by government institutions, but instead are supported by those government institutions. So that was, a series of very important principles that were set out. And, I've got an excerpt here from the decision itself, and it really is something that now gets read at many same-sex and other and opposite-sex marriages, because these statements about marriage are above and beyond who's actually getting married, and they actually talk about the importance of the right to marry itself. And one other thing that the court made it very clear in their opinion was that our whole nation and Western culture itself is built in large part on a commitment to support families and marriage. And so it is just crucial that governments support marriages, whoever is getting married, whether they be opposite sex or same sex. Of course, we had a good time after the decision was announced, and Jim and I were on the steps of the courthouse just in total joy. It was a delight to see Jim talking to the media. He even got a call from President Obama that day. And famously, while he's talking to President Obama, Vice President Biden went to voicemail because he had also tried to call Jim. So this was a day of celebration. And after many, many cases in which I lost in my advocacy on behalf of gay people, it was just a total delight to finally win. And I think it's the only case in my entire history where once we got back to Cincinnati, it happened to be Gay Pride Day. So we ended up in the parade celebrating Gay Pride and enjoying with the rest of the city the entire event. I'll also say that on the day of the decision, I called our mayor from the courthouse steps at the Supreme Court. And I told the mayor of Cincinnati that we had won and that there was a right now to marry across the nation, and that our office had been contacted by several same-sex couples who wanted to get married right away. And he was able to marry them that day on Fountain Square in the middle of our city, again, turning Cincinnati from an island of hate to a very welcoming and publicly welcoming city. And that's one of the things that I really want to emphasize, is that the story of the path to gay marriage for Jim and I involves turning Cincinnati from a place that had no use for gays to a place that now is actually exemplary in their acceptance of same-sex couples, in their banning of conversion therapy, in their inclusion of surgical services for transgender employees in their employment setting. So a lot has been accomplished, and I know I speak for Jim when I say, if we can help you do anything that's similar to what we got done in Ohio, we're here for you.